All right, it is 9:01. We'll go ahead and get started. Hi, everyone, and welcome to the Workers' Compensation webinar series presented by the State Office of Risk Management. My name is Annabelle Asp, and I will be your host along with Donna Goodwin. Our presenters today are Sky Myers, Senior Assistant Attorney General, and Tina Astrike, Assistant Attorney General. Both are from the Attorney General's Office Workers' Compensation legal team. Today's webinar will focus on PTSD, penalties, and red flags. Before we get started, I'd like to go over a few housekeeping items. If you aren't familiar with Zoom, you can find the chat function by scrolling over the bottom portion of your screen. Please enter your questions into chat. Following the presentation, we will answer questions if time allows. Donna will also be available to answer any questions at that time as well. The presentation portion of this webinar is being recorded, and both the recording and slides will be made available to you after the meeting. Without further ado, I'll hand it over to Sky and Tina. Thank you.
Thank you, Annabelle. Good morning, everyone. I know when you looked at your calendars for this week, this was the thing that you most look forward to. So thank you. Today, we are going to learn some more about the mysterious world of workers' compensation. It's a bit of a grab bag of topics, but we have some very important ones to talk about. Just as a reminder, we've now done 5 of these, and unfortunately for me, Donna has recorded all of them. Think of us as the YouTubers your children really don't want to see. We've covered pre-claim preparation, Rule 6 with modified duty and return to work, claim reopening, compensability, and subrogation. So if you are just starting out or want to learn more about workers' compensation, those presentations may be a great way to learn about some important topics. Donna Goodwin can provide the links to you at your request. And again, I'm Sky Myers. I'm a Senior Assistant Attorney General. I've been doing workers' compensation for over 11 years now, 7 with the Attorney General's office. I've represented employers and employees. And since I've done enough of these, I now have come up with random facts about me. Today's random fact is that my mother has repeatedly assured me that I am perfect, but for some reason, no one can explain my wife does not agree with that opinion. Joining me today is Ms. Tina Astrike. She has also worked for both employees and employers in the workers' compensation realm. She's a very experienced attorney, and she's been with the Attorney General's office for several years now. She has 2 dogs, is tenacious, and works as hard as anyone. We are lucky to have her with us today, and she is the star of today's show. And as a reminder, if you need help with the workers' compensation issue, all of the attorneys on this page are here to help you. So today we're going to move through a lot of material. First, we're going to talk about mental injuries, specifically post-traumatic stress disorder or PTSD in the workers' compensation realm. Then we'll dive into penalties and what those are and what the common ones that we see all the time are. And then we were going to talk about something pretty important and near and dear to our hearts, which is red flags and workers' compensation claims. This topic could probably be a presentation on its own, but we love talking about these, so we are going to shoehorn as much of them in as we can. And then, as a bonus, we're going to quickly talk about what an IME is and why it is important. And then we will have an unrecorded question section at the very end. Please save all questions for the end or type them in chat, and we will get to them at the end. And if you have any topics you'd like us to cover in the future, please email us, put them in the chat. These presentations are meant to help all of you. So if there's anything you want to know about, let us know. And before we dive into PTSD specifically, I just wanted to introduce the topic or the idea of a mental injury or mental impairment in workers' compensation, because it is a strange topic. The main point I want to make is that, yes, you can have mental only injuries in workers' compensation, but if there's no physical injury, there are a lot of restrictions tied to a mental injury, and not all of them are going to be talked about on this slide, but they exist. One of the main ones is that a mental impairment can't be based on facts common to employment, like a bad work review or a mean boss. Tina will talk more about that later. Second, as a threshold matter, a mental-only injury must do one of two things. One thing it has to do is be independently disabling, as in it must be serious enough to prevent the employee from working on its own, as in it just because of this mental injury, the employee cannot go back to work, whether for whatever reason. And or the mental injury must be serious enough that some form of medical or psychological treatment is required. And that brings me to my final point on this slide. These injuries are difficult injuries to handle in this system. It's not a broken leg with an X-ray that tells us exactly what's wrong. And mental injuries usually involve a lot of subjective information, reporting, and vague medical opinions. And that can be frustrating for everyone. This is hard for us as attorneys, the state's employees, and yes, all of you out there as well. And without further ado, I will turn this over to Tina.
Thanks, Sky. So as Sky mentioned, there are, in workers' compensation, PTSD or any sort of mental kind of injury is referred to as mental impairment. There are two types. One is disability from a work-related psychologically traumatic event, which we refer to as PTSD. The second is mental disability arising from a physical injury. So that would be somebody got physically injured, and because of that injury, they have depression, anxiety, that sort of thing. The biggest and most important part or piece of this is to have a work-related PTSD. It must be proven by the opinion of a licensed psychiatrist or licensed psychologist. This means that they have to address both that, number one, there was a traumatic work event, and that that event brought the cause of the PTSD diagnosis. So that takes us to the next slide. Thank you. Now, as long as there are things that are specifically excluded under a work-related claim for PTSD. These things, as you can see, are disciplinary actions, job transfers, layoffs, demotions, or promotions, termination, retirement, but only if they are taken in good faith by the employer. So as long as the employer has a good faith basis for the employment action, work stress claims based on any of these actions or the "my boss is being mean" claim should always be denied. Now, that doesn't mean that we prevent an employee from reporting or filing a work comp claim for these types of claims, or that we do not provide them with the designated provider list if an injury is reported with these kind of circumstances. It just means that ultimately the claim will be denied as not causally related to the work conditions or fall under the Work Comp Act. So examples of what may fall within the act could be actions of the employer that do not have a good faith basis, such as retaliatory actions. Additionally, and we always keep this in the back of our minds, is that even if it doesn't fall under work comp, there could be some sort of employment law action at play. We don't handle that. We do have a unit that does, though, so that doesn't mean that there might not be some sort of ramifications, just not under work comp. So now, what is a psychologically traumatic event? There are two definitions of this. The first and probably the most general one is the event is generally outside a worker's usual experience and would evoke significant symptoms of distress in a worker in similar circumstances. So events that are generally outside of workers' usual experience that would be within the course and scope of employment would be shooting at a job site, bank robbery, assault. I mean, no, these are kind of extreme, but I mean, psychologically traumatic event sometimes is pretty extreme. So some tips if you are reported, or if an employee reports a PTSD or psychologically traumatic event claim: investigate. We can't stress that enough. Talk to the claimant talk to the claimant's coworkers, talk to the claimant's supervisors about the incident or the claimant's presentation or statements after an incident. We can always agree to pay for treatment while we are investigating a claim, even though an admission hasn't been filed. So just because we're investigating or haven't fully admitted to a claim doesn't mean that we're leaving a quote unquote injured worker or somebody who's claiming a mental impairment injury just hanging out there. So one of the things that should be done is the claim adjuster should be getting medical records to determine if there's any other mental health issues that pre-exist or ongoing. These can help with narrowing down the treatment or delays. We can check CSAP. As you all know, that's the Colorado State Employee Assistance Program, which offers free counseling to state employees. They require their own release, but sometimes they're a great source of information. We can look to FMLA, look for FMLA claims, see if the employee has ever taken time off from work for something similar. This could also direct the claim adjuster to primary care physician records. Sometimes injured employees do not actually disclose who they are seeing prior to a work injury. And sometimes those FMLA documents will have the names of primary care physicians listed on them so that we can obtain records even if it's not disclosed. You never know what you might find. For example, I had a claim at a prior law firm in which the claimant worked for Qdoba and was beaten up pretty badly. He had a traumatic brain injury while he was reportedly taking out the trash. So come to find out in the medical records, it was reported that he had a history of psychological issues. So we requested those records from his previous counselor who was treating him. And lo and behold, he told that counselor that he knew the people who beat him up from a prior drug deal. And along with security video of the restaurant at the time or right before the incident took place, which actually showed the claimant left the restaurant without having any trash in his hands, as he previously reported, the employer was able to withdraw admissions on the claim based on a personal injury or a personal assault, which falls outside falls outside of workers' compensation. And we were able to do that 3 years after the work injury. So we paid for medical treatment, and at the time, I think they had filed a final admission, so they had paid for physical or PPD benefits as well, amounting to almost $300,000. And in the end, they were able to withdraw admissions and claim the overpayment, but good luck trying to get that back. Anyways, feel free to contact the work comp unit at the AG's office before a claim is accepted to be sure that there's appropriate evidence supporting a compensable mental impairment claim. We want to make sure we have the proper medical opinion. Again, it has to be a licensed psychologist or psychiatrist. Investigation tips, ideas, any sort of that. We like to address everything that should be addressed before we file an admission. So the second definition of psychologically traumatic event would be an event in a worker's usual experience. This is basically a first responder or 911 operator exception. So this is an event in a worker's usual experience when diagnosed with PTSD by a licensed psychiatrist or psychologist after an attempt by another person to cause the worker serious bodily injury or death by use of deadly force. The worker either visually, audibly, or both witnesses death or immediate aftermath of death as a result of a violent event, or the worker repeatedly, either visually, audibly, or both witnesses serious bodily injury or immediate aftermath of same as the result of an intentional act of another person or an accident. So these are typically, again, like our first responders appearing to accidents over a 20-year period. Eventually, it could take a toll. 911 operators. This is a new statute. It just went into effect not too long ago, primarily because these type of workers were excluded previously from PTSD claims under the prior statutes. So we didn't want to, the legislature didn't want to have them excluded, so the law changed. So as Skye mentioned, PTSD is not an easy injury to deal with. It's completely subjective. The injured worker could be dealing with other stressors that could delay treatment or become part of treatment. They could be going through divorce. They could have money issues. They could have prior trauma that they're also trying to deal with, and that could come up in treatment. And unlike physical injuries, there's no good way to see if someone is lying or malingering. Although surveillance and social media could still be beneficial and useful to see if a claimant is presenting inconsistent with reports to treaters. Things to look for: prior psychological records, prior treatment, issues that could potentially be used to narrow or focus treatment. Again, the more we know about what someone is dealing with, the more we might be able to try to narrow down the issues. But again, mental impairment injuries are one of those that it's difficult, because unlike a bone that's broke that you can tell when it heals, PTSD is not one of those. So mental impairment benefits: for if there is a mental impairment injury, it is limited to 12 weeks of benefits, including temporary disability benefits, unless the worker was a victim of a crime of violence, regardless of the intent of the perpetrator, or an injury or disease results in neurological brain damage. Typically, what we're more going to see more often or not is claims that the injured worker was the victim of a crime of violence. Crime of violence basically means any crime which involved violence or deadly weapon, but the legislator has clarified, regardless of intent, the cause is defined as an act or failure to act that is a natural and probable sequence produced the claimed injury. And that it's generally a question of fact for an ALJ as to whether an injured worker is the victim of a crime of violence. However, this generally includes assaults, but it does not have to be the person against whom a crime was directly committed, not a witness. So if it's just a witness, they witnessed a crime of violence, they were not the actual victim, then that is not enough to fall or get the benefits to fall outside the 12-week limitation. In a recent Industrial Claim Appeals Office decision, there was a claimant who was seeking more than 12 weeks of mental impairment benefits, claiming she was the victim of violence. Her case involved an injury in which she was a dog groomer and was working where a co-worker had brought in their dog, and the co-worker's dog bit the claimant. The co-worker was grooming her own dog, and the dog bit the claimant as she walked into that person's office to get a tool. And the ALJ in that case limited mental impairment to 12 weeks, finding the dog owner's conduct by bringing the dog to work and grooming him were not the natural and probable cause of the claimant's injury. And that was that decision by the ALJ was upheld by the Industrial Claim Appeals Office. So just some more tales from the bar. I've had a couple of PTSD claims. One of them was a new DOC corrections officer who was involved in a riot after just 2 weeks on the job. She witnessed other corrections officers being assaulted and beaten by prisoners. She herself, however, was not touched. The claimant claimed PTSD from the incident, which is probably not unreasonable. Upon investigation, claimant was also taking medication for PTSD related to being the victim of a prior assault before the incident at work occurred. Claimant also reported to treating providers she couldn't work, she could barely leave the house because of fear of being around people. The claim kind of drug on because, again, this is primarily based on the subjective complaints of the claimant. However, the claim adjuster got some surveillance, which actually, and surveillance is a crapshoot, but they just happened to find the claimant going to a bar in another state Nebraska, as it was. And they saw her sitting at the bar. People were passing behind her, and the claimant didn't actually have any sort of reaction at all to that. So that video was shown to the treating psychiatrist, who ultimately placed the claimant at maximum medical improvement without impairment. She eventually went to a dime, got an impairment rating, and then tried to claim she was the victim of violence so that she could get outside the 12-week limitation. But again, as she was not touched, that became an issue that also needed to be addressed as to whether or not she fell into that. Additionally, I had another PTS claim in which an administrative assistant at a community college filed a work comp claim due to alleged sexual harassment by your supervisor. Now, typically sexual harassment is considered a private assault, which falls outside of the course and scope of employment. In this case, we also had a statute of limitations issue. So we had several defenses as well. At the time that claim was filed, the act required the claim of a mental impairment to be proven by evidence of a licensed physician or psychologist. Now it requires a psychologist or a psychiatrist. So this claimant also had pre-existing issues of PTSD, and she was getting treatment through CSAP, where she was getting counseling. So we obtained those records as well. She was also on medication and getting counseling at the time that this alleged work incident occurred. At the hearing, this case went all the way to a hearing because we had denied it. The claimant testified, and she presented the testimony of her licensed practicing counselor who had diagnosed her with PTSD. However, the claimant failed to prove any medical evidence from a licensed physician or licensed psychologist, as the act required, to prove that her PTSD diagnosis was caused by the alleged sexual harassment. And so therefore, respondent won on a motion for dismissal or directed verdict as of the claim because the claimant failed to meet her burden of proof. So these claims can be quite interesting. So, Sky?
All right, thank you very much, Tina. All right, so now we are done with PTSD for now. We can answer any questions you have later. But we also want to talk about something that's very important, and that is penalties. What are penalties? In workers' compensation, penalties are monetary fines that either the director of the Division of Workers' Compensation or a judge of the Office of Administrative Courts can award for violations. Violations of what? The penalties are assessed for one of three reasons. Someone violated a workers' compensation rule, statute, or order. And for context, I looked this up last night. The 2021 Workers' Compensation Act, or the collection of statutes that control workers' comp in Colorado, is 125 pages of mostly single-spaced text. The font size is 10, and that doesn't count the workers' compensation rules, of which there are many. So the point is there are a lot of ways to get in trouble. And yes, both sides can get in trouble. Unfortunately for us, there are a lot more ways for an employer to get in trouble than there are for employees. Now, penalties can happen, and if the Division of Workers' Compensation or an ALJ determines that there is a penalty violation, they can penalize the offending party for each violation up to $1,000 per day. And yes, this adds up to $7,000 per week, or up to $365,000 per year per violation. And the whole purpose of this slide is not to impress upon everyone that I'm good at math or that penalties add up. It's that they add up quick. So we need to do whatever we can to A, not create a penalty, and B, if we find one, fix it. If you cure the penalty, that daily addition stops. And I want to highlight some of the more popular ways that we as employers can get in trouble. The first is we don't report an injury that is we know or think may be work-related that is causing an employee to miss work or is serious. And if we don't do anything in these claims, we're in trouble because we have 10 days to report that injury before penalties can begin accruing. And to double down on this, after we are supposed to have reported a claim, We have 20 days to then admit or deny that claim if it is serious enough. If we don't, the penalty begins again. So if we fail to report and then fail to admit or deny an injury, that is 2 separate penalties accruing up to $2,000 per day, every day. So we need to stay on top of injuries or notice of injuries in a big way. Another common one is if the employer is found to be directing medical care. This basically means telling the employee's doctor what to do. For example, telling them what the restrictions need to be, or to release the claimant to full duty, or to put them at MMI, or ask for impairment. Don't do any of those things if you end up talking to a physician for whatever reason. As an aside, employees can't do this either. They can't tell the doctor what they want the doctor to do and have the doctor do it. But most commonly, this is an employer problem. And claimant penalties also exist. And we want you guys to know about some common ones, because if you can issue spot and report on them, that helps us a lot, because it is vital that we know about any potential claimant violations as soon as possible before we admit or deny a claim. A common one, and this may change because the legislature is in session, but if the employee is more than 4 days late in reporting an injury, they could have their benefits reduced. This is a big one. If an employee violates a publicized and enforced safety rule, and that causes their injury, their benefits should be reduced by 50%. Please tell someone immediately if a safety rule was violated or may have been broken. Failure to disclose physical limitations. If an employee says they can physically do a job, but is lying, that can also reduce their benefits. For example, if an employee has a bad knee, but they said, hey, yeah, I can do security rounds for hours a day, 40 hours a week, that could be a violation if they end up with a knee injury. And so they would have their benefits reduced. And this is another big one. If an employee is drunk or high in some way, and that causes their injury, that's a reduction. If they're supposed to be using a seatbelt or some other safety device and don't, and that causes their injury, their benefits can also be reduced again. And fraud. This is kind of a catch-all here, but if an employee is lying about being injured or how injured they are, it may not be a standard penalty, but it's something that could get them in a lot of trouble or prevent the state from paying out unnecessary benefits if we catch them. So please, if you see something or hear something, report it. And with that, we are done with penalties for now. I'll turn this over to Tina to talk about red flags. I think it'll take her only about 45 minutes to get through the next slide.
I don't know, I talk pretty fast, so it might be 45 seconds. So I'm going to talk about red flags in the beginning of a claim. There's so many that this is not an exclusive list. Later, delayed report of an injury, repeat offender, multiple claims, grapevine, coworkers are saying, hey, I heard this guy did something over the weekend and that's how he got injured, and not from whatever it is he's saying that he did out in the yard or walking to the parking lot or whatever. Similar are pre-existing conditions and complaints. Somebody talking about a back injury or back pain that they've had for years, and then all of a sudden they quote unquote slip and fall unwitnessed, and now they're talking about back pain. Again, look to the ADA, FMLA, look prior claims. Again, no witnesses. That's kind of a big one for me. I mean, if no one witnessed the incident that happened, are we sure it even really happened? We don't know. Recent or ongoing personnel issues. Were they counseled in regards to doing something inappropriately right before they reported their injury? New employees. What do we know about them? Nothing. They're new. So maybe it requires a little bit more investigation. If they were injured, again, within 2 weeks or so of the job, 2 months maybe. Changing story. They said they did something and then all of a sudden, no, they didn't do that thing. They did this and then they did that. And the story keeps changing how they were injured. They're being pushy. They want benefits. They want to get paid for missing work. They want They're just, everything has to happen right now. Video or Facebook. Does video show, is there a security video of the incident? Facebook, does Facebook show that maybe something else maybe happened? Unresponsive to questions, or they're being cagey. This happens a lot, mostly on the claim adjuster's end. You'll see that they don't want to provide information as to prior injuries or prior accidents, or they don't want to provide information regarding prior conditions that they're treating for or have, like diabetes or something else. Refusing to provide releases and provider list. Again, that typically happens on the claim adjuster's end. Failing to disclose other injuries or accidents. Happens all the time. Happens all the time. So mainly the tip on this is, if you hear something, say something. Yes, I know it sounds like a terrorist plea, but that is PTSD or public safety announcement, but that's not it. Employer, share your concerns of red flags, if any, with the claim adjuster. If they don't know, they could file an admission on a claim, and then we, the respondent and employer, bear the burden of proof later on if we want to try to challenge the injury or claim exists. Prior to an admission, is the claimant's burden to prove that a compensable work-related injury happened. Again, coworkers can be great sources of information. It could lead to additional information like Facebook. CDOT had a claim where the claimant alleged a back injury. Then one of his coworkers happened to mention that he thought that the guy said he did it riding dune buggies or something, which led to an investigation, eventually found Facebook evidence, surveillance, and ultimately a denial of the claim as being not work-related. Again, I'm pretty suspicious by nature. So new employees, what do we know about them? Nothing unless they tell us. So let's do some investigation on those new employees regarding prior claims. Let's see if they have something. Again, kind of tying it into what Skye had said about penalties. If somebody has a prior work injury for which they receive permanent restrictions, but they don't tell their new employer about it, and we don't know about it, but yet they're injured, and it's because they were working outside of their permanent restrictions. You know, these are things that we should know about, and we definitely want to do an investigation to see if something like that has happened, because even though it doesn't get rid of the compensable nature of the new injury, it may allow the employer a 50% reduction of benefits. Once you hear about an injury, employers, please always check to see if there's security video of the incident. If so, preserve it. It could be useful to provide to the treating provider or an IME to determine whether there was an injury or whether there was just an incident. Even if there's no question whether there was an injury, like somebody broke their leg and bone is sticking out, that it could still be used to provide to a treating provider and IME later to determine causation of additional complaints. Could the mechanism of injury seen in the video have caused an ankle injury or shoulder injury that they're now complaining about, even though they didn't report it right away? Remember, even if you, the employer, do not see a red flag, the claim adjuster could on their end. Again, as discussed, claimants they're not cooperating by providing releases or medical provider history. They're being cagey. They're not discussing all information like past treatment or conditions or injuries or accidents. And we later discover those in insurance claims searches that shows, hey, claimant had a motor vehicle accident like a month after they reported the injury. These are things we should investigate and can investigate. Now, again, doesn't necessarily mean that the claim is not always compensable, but it definitely, we should do our due diligence and find out as much information as we possibly can before we file an admission.
All right, thank you, Tina. One thing I'll jump on was with the videos. If they got injured in a facility, often there's footage of them walking into that facility that morning. And if they're claiming an injury and they hobbled into work that day, that's something we'd like to know. And how'd they walk out of that facility? So even if there's not video of the incident, there's often video that can help us determine whether there was a claim or a real injury. And sometimes it helps us simplify investigation, because if they walk in fine and don't walk out, then we know that any other concerns we might have are probably something that we can discount. So just an idea there to keep that video search broad. And just because a claim is accepted and ongoing doesn't mean that we are in the clear and we can turn our brains off. Strange things happen as claims progress. For example, if the employee just is never coming back to work, especially if the injury was not severe at the beginning, it seems it's probably a troubled claim and we need to keep an ear to the ground. If an employee returns to work very briefly, then immediately leaves or gets the restrictions changed so they can't work anymore, that's trouble. That's all, especially if they're actively doing that. That's always something that concerns us. And if pain is getting worse, not better as time goes on, that's a sure sign that things are not going well and you should be on alert. That typically means that the employee is starting to think about things other than getting better. And if body parts get added to claims as they drag on, if a knee claim is now a low back claim, for example, that's a good sign a claim is going poorly. And the focus for the employee is not about getting better, about increasing claim value, or at least they're in their own head and they're thinking about pain more than improvement. It's always a sad situation when that happens. Vacations. If you hear an employee that is too injured to work or limited, is off gallivanting around the globe, that's worth reporting or getting more information on. Maybe their vacation is just a much needed spa treatment, or maybe that employee with a severe neck injury is actually paragliding around South Beach, Miami. That is a true story. I had a claimant who was unable to look at a computer screen or rotate her head at all, but was quite capable of landing in the Atlantic and taking back off again. And I want to conclude our discussion on red flags with a caveat. We are not passing judgment on employees here, saying we think all or even a lot of employees are gaming the system. We are just suspicious lawyers. Please forgive us. And sometimes red flags don't mean anything. However, we are passing along some things to keep an eye out for because we need you to help us manage the state's workers' compensation claims. All of you are a lot closer to these employees than we are at the AG's office, so we need your help keeping an eye out for warning signs. Thank you for that help. And quicker than I thought possible, we are nearing the end, and we're going to talk about IMEs. In workers' compensation, we often face complicated medical issues. And as much as some of us would wish otherwise, we are just lawyers, not doctors, and we, or your adjuster, often need help addressing all sorts of medical questions. So, an IME is an independent medical examination. It's a doctor we have selected, the employer has selected, that evaluates the employee to help us address medical question in a claim. And it's important to note that the employee is not a patient of this doctor. That doctor is just evaluating the employee. They are not treating them. And there are a few reasons we really like to have IME, some common ones. The most basic one is whether the incident in question actually caused the claim injury. Did that slip and fall cause their upper back condition, or was it related to a motor vehicle accident the prior week? So that'd be a great question to ask if we knew about that MVA. And another thing we like to know is, what care does the employee need to get better? A good example here would be whether that fusion back surgery for a 25-year-old is a good idea. And spoiler alert on that one, 25-year-olds generally should not be getting fusion back surgeries, although some doctors really do love to perform those surgeries. And we also want to know just how impaired or permanently injured the employee is from their injury. What are their range of motion limitations from their shoulder injury, for example? And we also need to know what work can the employee do? Are they able to lift 20 pounds? And how often can they lift that 20 pounds? Can they lift that 20 pounds overhead? How long can they walk? All sorts of very important, but often boring questions. And one thing to clarify is that an IME is not a dime. The division independent medical evaluation or examination is a very different thing that the employer does not control. It is just part of many workers' compensation claims And we don't get to choose often when that happens or who the doctor is. I'm sorry if that is confusing, but I am an attorney and I have to uphold the profession's reputation. So with that equivocation, everyone, I'm sorry to interrupt, but your mid-morning Tuesday nap is over. Again, if you have any topics you'd like us to cover in the future, please put them in the chat or send us an email or give us a call. These presentations are meant to help you. So if there's anything you want to know about, let us know. And as a reminder and a plea, if you have a question or problem in the workers' compensation arena, call us or email us. We are here for you. And when I found this picture, I thought about the last time I'd seen an actual phone booth. And then I went down a tangent of, I don't know what Superman would change in these days, maybe an Uber or something. And with the bad joke, we are on to questions.